Performance of contract. Very important aspect of the law of contract. After having formed the contract, what is to be done? Obviously, the answer is the performance. Performance is a rule, breach is an exception. And mind well, this we have not to learn from the law of contract. We have been in the tradition that prana jaya par vachana na jaya. Promises are given for performance. The same thing is incorporated in section 37 of the Contract Act and says that what is the obligation of the parties? Obligation of the parties. Section 37 says the parties to a contract, means both the parties, must either perform or offer to perform the respective promises. So burden is on both the sides. Unless such performance is dispensed with or excused under the provisions of this Act, means the Contract Act, or any other law. Pausing here for a moment. In substance, the section says that both the parties are under obligation to perform or offer to perform their part of the obligation. The exception is only when the performance is dispensed with either under the provisions of the Contract Act itself or under any other law. Most important thing, that promises bind the representatives of the promisors in case of the death of such promisor before performance. Meaning thereby, if the promisor dies, his obligation continues on the representatives unless and until contrary intention appears from the contract. Look at the illustration. Promise to deliver the goods at a price and the promisor dies. The representative of the promisor is under obligation to deliver the goods, and the promisee is also under obligation to pay for the same. The second illustration says about when the performance is excused, where the promise is to paint and the painter dies before the appointed date. The contract cannot be enforced either by promisor or promisee. Look here. In the last section, I have told you about must perform or offer to perform. What is offer to perform? Offer to perform technically in law is known as tender, and section 38 makes provision for the same. And virtually you will see that the tender amounts to performance in some sense because it relieves the other party. Look at section 38. It says where a promisor has made an offer of performance to the promisee and the offer has not been accepted, the promisor is not responsible for non-performance, nor does he thereby lose his rights under the contract. So the provision is both the way. Once the promisor offers himself to perform and the promisee refuses to accept, the promisor is relieved of his obligation and at the same time retains his right in law to sue for the necessary consequences. But then, what should be the nature of tender? That is also prescribed. And look at the conditions. The first condition is that tender must be unconditional. Go back to the offer and acceptance. Specific offer, unconditional acceptance. Same way, tender also must be unconditional. The second important condition for such a valid tender is that it must be made at a proper time and place. So it's not that at any time when you wish you can offer, knowing full well that performance offer is bound to be rejected. No. Law says it must be made at a proper time and place. And under such circumstances, that person to whom it is made may have a reasonable opportunity of ascertaining that the person by whom it is made is able and willing, both there and then, to do the whole of what he is bound by his promise to do. So this is the nature of the offer to perform, the tender. Meaning thereby it must be made at a proper time and place, and there must be a reasonable opportunity to the promisee to ascertain that the promisor is prepared, ready and willing to perform the whole of it then and there. Such a wide coverage of the tender. The next condition is, if the offer is an offer to deliver anything to the promisee, the promisee must have a reasonable opportunity of seeing that the thing offered is the thing which the promisor is bound by his promisee to deliver. Meaning thereby, there must be an opportunity to the promisee to ascertain that the same thing is being delivered. There is no change. The most important aspect is that when there are joint promises, last line is important and says, an offer to one of several joint promises has the same legal consequences as an offer to all of them. So when there are more promises, one need not make tender to all. If it is made to one, law says it amounts to all. If tender is satisfying these conditions, then only it would be a valid tender and would absolve the promisor of his obligation, not otherwise. Please note. Now look here. Section 39 says about refusal. When a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or conduct his acquiescence in its continuance. In short, this section prescribes that when party refuses to perform or disables himself from performing by some act, his promise in its entirety, mind well, not a part, The question is about non-performance in its entirety. In such situation, the promisee gets a right to put an end to the contract. But then also, the rider is that if he has signified by his words or conduct his acquiescence in continuance of contract, then he is not relieved. Now look here. Section 40 speaks about the person by whom contract is to be performed. And in substance, it means that if there is intention that it must be performed by the promisor himself, then promisor himself. In all other cases, it may be performed by any other person. Look at the section. If it appears from the nature of the case that it was the intention of the parties to any contract that any promise contained in it should be performed by the promisor himself, such promise must be performed by the promisor. In other cases, the promisor or his representatives may employ a competent person to perform it. The best example is the audit work. Engaging a chartered accountant, and the audit work is done by his agents. Here also the illustrations speak about the same thing. The payment of money by A, but the other person makes the payment. It's a valid performance. But if the contract is to paint, then painting must be done by the promisor personally and not by his representative. Look here. This section simply relieves the promisor in one way. It says, section 41, when a promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promisor. It's very simple to understand. If I have to pay you 1000 rupees and my close friend makes a payment and you accept, subsequently, can you demand 1000 rupees from me? The answer is no. That is what the substance of section 41 is. That having accepted the performance by third person, you cannot again demand the performance from the promisor. This section is very important about liabilities and speaks of devolution of joint liabilities. Mind well, once there are joint promisors, what is the effect of it on the contract? And section 42 speaks that when two or more persons have made a joint promise, then unless a contrary intention appears by the contract, all such persons during their joint lives and after the death of any of them, his representative jointly with the survivor or survivors, and after the death of the last survivor, the representatives of all jointly must fulfill the promise. Meaning thereby, when persons have made promise jointly, unless the contrary intention appears from the contract, if any contrary provision is made in the contract, then all such persons during their lifetime, and in case of death, the survivor, along with the representatives of the dead, and in case of the death of all the promises, the representatives of all the promises are jointly liable to fulfill the promise. In case of joint promises, what is the situation? Who can be compelled? And Section 43 answers that situation. Any one of the joint promisors may be compelled to perform. Look at the section. When two or more persons make a joint promise, the promisee may, it is the discretion of the promisee, in the absence of any express agreement to the contrary, compel any one or more of such joint promisors to perform the whole of the promise. This gives liberty to the promisee. You, as a promisor, cannot say that not me, go to the other promisor. It is the option available to the promisee to approach any of the joint promisors and compel him to perform the obligation. At the same time, law also makes provision that when such situation arises, what is the remedy to the promisor so compelled? And it says, each promisor may compel contribution. Meaning thereby, it says, each of two or more joint promisors may compel every other joint promisor to contribute equally with himself to the performance of the promise, unless a contrary intention appears from the contract. So, the joint promisor who is compelled by the promisee is entitled to ask for equal contribution from other joint promisors. Situation may also arise that the joint promisor makes a default. Law also makes provision for that situation and says sharing of loss by default in contribution, stating that if any one of two or more joint promisors makes default in such contribution, the remaining joint promisors must bear the loss arising from such default in equal share. So, there also equality. If there is default by one or more joint promisors, the loss is to be borne by the other promisors equally.